Okay, I think we'll start. So, good morning, everyone, and thank you all very much indeed for joining us for this extended cover talk case roundup. My name is Andrew Tobin. I'm a partner specialising in insurance and reinsurance at Mills and Reeve, and I'm joined today by my insurance law colleagues Claire Roake, Bradley Needham, and Andrea Stanford. And over the next 40 minutes or so, we'll be summarising a few cases from the last year from a range of classes of business, primarily with an eye on coverage, but not exclusively. We'll look at aggregation, coverage under a PI policy, jurisdiction and anti-suit injunctions, products and public liability coverage questions, the scope of a professional's duty to third parties, and war risk exclusions in property policies. We've decided not to discuss the various COVID business interruption decisions because they're extensively discussed elsewhere and would eat up too much of our time today. You can see us, but we can't see you. A recording will go out afterwards with the slides. Of course, please do contact any of us directly should you have any questions. So I'll hand over to my colleague Claire Roake to get the ball rolling.
Thanks, Andrew, and good morning, everyone. So I'm going to kick off by discussing two recent cases concerning solicitors' professional indemnity. The first is Discovery Land and Axis, which was the subject of a Court of Appeal decision last month and which concerns aggregation and dishonesty. And second, RSA and Tuggins, which is another Court of Appeal decision concerning whether there can be professional indemnity cover for the repayment of lawyers' fees. So looking first at Discovery Land and Axis, now the facts behind this coverage dispute are quite remarkable because of the scale of the solicitor's dishonesty. Now, Discovery Land is a US property development company, and in 2018 it sought to acquire Taymouth Castle, which is a 180-year-old castle in the Scottish Highlands. The purchase price was $14 million US. Discovery Land instructed Stephen Jones, a partner of a firm of solicitors known as Jai House Partners LLP, to act for it in the transaction. The Jai House was a two-partner firm, and the other partner was a Mr. Prentice. Now, in the course of the transaction, $14 million was transferred to Jai House's client account. Now, the money should have been held pending completion, but they were immediately misappropriated by Mr. Jones. Mr. Jones and Jai House was at that time in significant financial difficulty. Mr. Jones also procured a £5 million charge over the castle without Discovery Land's knowledge or consent. Now, in 2019, Mr. Jones's actions were uncovered, and he's now serving a lengthy prison sentence. Jai House was wound up and Discovery Land pursued a claim against Axis, Jai House's PI insurer, pursuant to the Third Parties Rights Against Insurers Act 2010. The issues in that claim were whether Axis was entitled to decline cover for dishonesty, and as I'll explain in a moment, that hinged on whether Mr. Prentice condoned Mr. Jones's dishonesty. And second, aggregation. Under the policy terms, was the misappropriation of the $14 million and the subsequent £5 million acquired by Mr. Jones by charging the castle one claim or two? So looking at each issue in turn, so did Mr. Prentice condone Mr. Jones's dishonesty? The Jai House's PI policy was subject to the SRA's minimum terms of cover. Now, I'm not going to read it out, but the dishonesty exclusion from Jai House's policy is on the slide. Now, there was no question at all Mr. Jones was dishonest. He took client money and a lot of it. But Mr. Prentice was not involved in the theft of Discovery Land's money. The question was whether he had condoned Mr. Jones's dishonesty. Now, the Court of Appeal agreed with the trial judge that the word condone should be given its ordinary meaning. So to condone means to treat as acceptable conduct, which is unlawful or morally blameworthy. The Court of Appeal also considered the policy exclusion was wide enough to include the condoning of a pattern of dishonest behaviour of the same type as that which gives rise to the claim. So, for example, if partner B knew that partner A was regularly using client funds, it would be difficult for partner B to argue that he was unaware of a specific instance in which client funds were taken. Now, in this case, Mr. Prentice's conduct was found to have been unprofessional and at times dishonest. His evidence at trial included both truths and untruths. However, the Court of Appeal was satisfied that Mr. Prentice did not know what Mr. Jones was up to. He had not condoned the theft of such large sum from Jaya House's client account. So Axis could not rely on the dishonesty exclusion. So the second issue was aggregation, and the aggregation wording from the policy is on the slide. And this is taken from the solicitor's minimum terms, and the relevant part for the purposes of this claim is in bold. Now, Axis sought to argue that the claims for the theft of the $14 million intended to purchase the castle and the claim for the £5 million acquired by charging the castle should aggregate. They were similar acts or omissions in a series of related matters or transactions. The argument failed before the trial judge, and Axis also failed again in the Court of Appeal. It was found that a similar series of acts did not cause the loss of the $14 million and the £5 million. In a broad sense, the loss of both sums arose from Discovery Land's acquisition of the castle, but that was not enough. It's necessary to look closely at the substance of the two claims, and once you do that, they're quite different. The first claim concerned the theft of purchase monies, and the second claim arose from events months later and concerned the arrangement and drawdown of a charge. So Axis had to provide cover for two claims. So what can we conclude from the judgment? Well, I don't think the case changes the law. It does, however, provide useful clarification for the first time at Court of Appeal level of the meaning of condoning dishonesty. It is also a useful reminder of the need to look closely at both the particular policy wording and the facts when considering whether one or more claims aggregate. So I'm now going to move on to look at RSA and Tuggins. Now, the facts in this claim are complex, but in brief, Mr. Coulter, a former partner at Tuggins Solicitors, was engaged by Brown Rudnick in relation to a sale of loans. Mr. Coulter didn't open a file, and the other partners at Tuggins were unaware of his involvement. Now, a buyer was found for the loans, and Brown Rudnick sent a letter of engagement to the buyer. This provided that Brown Rudnick was entitled to a success fee of £15 million upon completion, and that success fee was to be shared with Tuggins. The terms of appointment included various warranties and representations by both Brown Rudnick and Tuggins. The sale completed without issue, and Brown Rudnick sent £9 million, which was Tuggins' share of the £7.5 million success fee, plus VAT, to an account that Mr. Coulter specified. Mr. Coulter told his partner that he had earned a fee of £1.5 million, and he transferred the additional £7.2 million to a company in his name. Mr. Coulter later revealed the true position to his partners and returned the money. Brown Rudnick issued proceedings against Tuggins, including for fraudulent misrepresentation, and the claim for damages included the success fee paid to Tuggins. The Tuggins insurers, RSA, declined the claim, and Tuggins sought a declaration that it was entitled to an indemnity in respect of any liability to refund the success fee. An arbitration followed and concluded with a finding in Tuggins' favour. RSA appealed to the High Court and lost again. Permission to the Court of Appeal was granted in relation to what constitutes an insured loss. Now, RSA argued that Tuggins had not suffered a loss on the basis that Tuggins' fee was procured by misrepresentation. Tuggins therefore had no right to retain the fee. And as such, if Tuggins was obliged to return the fee as part of a damages claim, it had not lost something to which it was entitled. And consequently, RSA argued that insurance cover for that element of the damages claim would violate the indemnity principle, by which I mean that Tuggins would receive more in fees than it could have recovered from its client. Now, the Court of Appeal rejected RSA's argument for several reasons. First of all, it was found that Tuggins was entitled to the success fee. It had completed contractually agreed work and had earned, and that was therefore entitled to, the fees charged for that work. The fact that it was argued that Tuggins' fee was procured by misrepresentation did not alter that position. Second, the court considered it significant that professional indemnity cover for solicitors has a regulatory and a public interest function. As a result, the insurance clause is in very wide terms and does not draw any distinction between liability for fees and other forms of liability. the Court of Appeal considered that excluding cover for the fee element of the claim may leave clients unprotected in circumstances where solicitors' fees have been paid. And third, it was relevant to consider the composite nature of solicitors' PI. It's treated as if separate insurance contracts have been entered into with each individual insured. So if liability for fees was irrecoverable, that would leave individual innocent parties uninsured for liabilities in respect to fees that they had not received. And that's contrary to the protection intended by composite cover. Now, in conclusion, before this decision, it was widely believed that claims for an indemnity in respect of a solicitor's own fees could not attach to a professional indemnity policy. However, the Court of Appeal's decision makes it clear that for insurance purposes, being deprived of a fee for a professional service can constitute a loss. Now, as is often the case, it will be important to consider the facts in each individual case, because fees will not, for example, be recoverable if they're unpaid or the contract with the client has been rescinded. So I will now hand over to Bradley, who will consider 2 more cases.
Thanks, Claire, and good morning, everyone. Today I'll be looking at the 2 cases shown on the screen, Aon and Lamia, and Sky versus Riverstone. Starting with the Aon case, I've chosen this because it's a good illustration of how the English court system can and will step in to rescue the litigant who is falling victim to a challenge over jurisdiction. Here, the defendants were seeking an anti-suit injunction, or ASI, against the claimants to prevent them from continuing with proceedings in Florida. They wanted the matter dealt with in England. So what happened? Well, it involved a fatal plane crash in Colombia in November 2016, where 71 people died. The relationship of all the relevant parties is shown on the screen. The insurance position was this. The plane was operated by a Bolivian company, Lamia. They were insured by BISA, a Bolivian insurer. That policy was 100% reinsured by London underwriters, Tokyo Marine Kiln, or TMK. The reinsurance policy was placed by BISA through its local Aon broker and Aon UK Limited. Following the crash, BISA declined cover because flights to Colombia were excluded without underwriters' consent, and that had not been requested. As a result, the declinature was accepted and BISA released and waived its rights under the reinsurance. TMK agreed to indemnify Lamia up to the $25 million policy limit without prejudice to coverage. Not unsurprisingly, the representatives of the deceased brought a successful claim in Florida against Lamia, who admitted liability and that there was no coverage under the BISA policy. Their claim was for wrongful death and negligence. The owners of the aircraft negotiated settlement agreements, but Lamia never executed them. The total damages were $844 million. Those agreements contained an assignment from Lamia to BISA of all of its causes of action against any broker involved in placing the insurance or reinsurance. Under Florida law, it enabled the representatives of the deceased to bring proceedings against Aon, BISA, and TMK. So what was the response of the insurers? Well, Aon sought to argue that it had no liability as a reinsurance broker, and any claims against it were subject to the terms of the business agreement, or TOBA, which it had with Lamia. That TOBA contained an English jurisdiction governance clause. TMK and their case was not as strong, as they argued that England was the appropriate forum supported by the validity of BISA's deed of release. Under that deed of release, it provided that English law should link to any dispute between the parties, and it also contained an English jurisdiction clause. They both applied for ASIs to restrain the Florida claimants from pursuing proceedings in the USA. Now, the outcome of the ASI sought by both parties is shown on the slide, and the outcome wasn't identical for them. For Aon, the English court stepped in to help. They held that the terms of the business agreement, including the English jurisdiction clause, was wide enough to cover any claim that Lamia might make against Aon arising out of placing the reinsurance. Although the claimants weren't party to the agreement, their claims were derived from Aon's obligations to Lamia and accordingly subject to the terms of that agreement. The case for the ASI was quasi-contractual, and the injunction was to be granted unless there was a strong reason not to do so, and that didn't exist here. The position for TMK, as shown on the slide, wasn't the same. This was because essentially the court found the bulk of the claim remained capable of being determined within Florida law. There were remaining issues and objections concerning liability, levels of quantum, and other procedural matters, all of which could be argued under Florida law. As a result, the court refrained from making an order that could interfere with the Florida court's ability to deal with the case. So TMK's ASI failed. I know that Andrew's recently had an ASI case of his own, and I'm going to open the floor to him to chip in at this point.
Thank you, Bradley. Yes, I just wanted to mention that we have an interesting political violence reinsurance case concerning property in Afghanistan. English law and jurisdiction apply to both underlying policy and to the London reinsurance. That was very inconvenient for the insured, who started proceedings directly against reinsurers, not in London, but in New York. And they secured in New York an interim anti-suit injunction to try to prevent us even taking countermeasures in London. We were able to persuade the New York court to lift that injunction, which then allowed us to go to ask the High Court in London to take jurisdiction, which it has now done. And the decision is not reported, but the High Court also granted our clients an anti-suit injunction and an anti-suit injunction, preventing it from reactivating New York proceedings, and the matter's now firmly being litigated in London. It's believed to be the first ever anti-suit injunction granted by the High Court in London in a quasi-contractual context, because we act for reinsurers and we don't have a direct contract with the insured. I can't say much more about it right now, other than to say, watch this space.
Thanks, Andrew. Turning to my second case, Sky and Riverstone. This revolves around the operation of a contractors all risk or CAR policy. I've chosen it because it reinforces the period for reinsurance cover following the case of Wasser and Lexington, and also whether you can be a party to a contract simply because you're a party under the insurance, which is covered under the contract. On the slide, you can see Sky's new London HQ, which was built in 2014 and 15 by Mace Limited. Mace subcontracted the design and construction of various aspects of the build to various different subcontractors. The roof design was made up of a series of glued together timber beams, where rows of wooden cassettes, which are prefabricated roofing components which have materials like insulation within them, were placed together. These cassettes were left in situ around the winter of 2014-15 without any temporary cover in place. As a result, water got into the cassettes and they suffered from mould and decay. Sky and Mace brought a claim for an indemnity against the subcontractors under their CAR policy. They said that the roof issues wouldn't have occurred had a temporary roof been erected. As a consequence, they would either need to replace the roof in full, or alternatively, replace the wooden cassettes with steel ones. Their claim was for about £200 million for the losses sustained not just in the insurance period, but also for defects that might come to light after the insurance period expired, but still stemmed from the same roof issue. Now, defence insurers argued that their liability was limited to damage proved only to have incurred during the insurance period and no later. They also argued that Mace wasn't a named insured under the CAR policy, or in the alternative, that it was only a co-insured up to the point of practical completion. In respect of quantum, if the claimants succeeded with their claim, the defendants argued that the cost for the remedial work should be around about £38 million, not £200 million. Now, the crux of the case turned on the interpretation of the CAR policy, and there were 5 issues which the judge needed to grasp at trial, as shown on the slide. Now, I'm going to briefly discuss 3 of these issues, which we found particularly interesting. The first was whether or not Mace was a named insured under the policy. The short answer, they weren't. The judge applied the decision in FM Conway and the RFU, which broadly speaking, held that a person who is named as an insured on an insurance contract, but who isn't a party to that contract, doesn't become a party to the contract simply by being named in it. As such, Sky alone was covered for the maintenance period under the CAR policy, and Mace's claim for indemnity was limited to the losses up to the date of practical completion. Turning to the period of cover, the key issue for the court was what losses should be covered during the reinsurance period. Those incurred solely during the insurance period of cover, or those incurred after the insurance period expired, but the root cause or loss began during the insurance period. The court applied the decision from Wasser and Lexington, which supports the principle that the period of reinsurance cover only covered damage during the period of cover under that policy, not after it expired. Finally, the deductible. Under the policy, there was £150,000 excess for any one event. The issue for the court was to assess what was defined as one event. Applying Stonegate and MS Amlin, the judge accepted the claimant's argument that there was only one event, namely that the damage was related to the decision not to install a temporary roof. Therefore, only one deductible needed to be paid. The Sky case is still being argued about in respect of quantum, and that hasn't resolved yet, so watch this space as there may be further developments on it. In conclusion, two rather knotty cases, but both are useful reminders of the circumstances when the English courts will intervene to help litigants facing jurisdiction issues with an ASI, and how the decision in Wasser and Lexington is applied by the courts to clarify what losses will be covered during the period of reinsurance. I'm now going to pass you over to Andrea, who's got another couple of cases to discuss.
Thanks, Bradley. I'm going to talk about two cases of a different nature. The first, ATA and HDI Global, considers coverage issues relating to damage caused by defective cavity wall insulation. The second, McLean and Thornhill, reinforces aspects of the duty of care owed to third parties. Starting with ATA, the facts are illustrated on the slide and are fairly simple. Mr. Atta bought a two-storey end-of-terrace house. At the time, there were no known issues with mould or damp. 2 years later, he employed Heatwave Energy Solutions to install cavity wall insulation. About 5 or 6 months later, mould and damage appeared and progressed throughout the property, including crumbling plaster, flaking paint, and rotten skirting boards. Mr. Atta commenced litigation against Heatwave, claiming losses for breach of contract and negligence. The court held that there was no physical damage to the building when the cavity wall insulation was installed, but that Heatwave had been negligent in the method of installation, which was wholly incompetent and left voids within the cavity walls. By the time of trial, Heatwave was in liquidation, leaving Mr. Atta to claim under the Third Parties Rights Against Insurers Act. Now, there were 3 consecutive insurers, but the court applied HDI's policy, which covered the period in which the damage occurred. Whilst the judge accepted that there was progressive damage over later years, it was the negligent installation which gave rise to the damage. Heatwave's liability of around £34,000 extended to the full cost of removing the cavity wall installation to avoid further damage arising. Insurers appealed and the court dealt with 3 specific issues, which can be seen on the slide, and covered the applicability of the policy, the remedial work, and the progression of the damage. Now, the first question, did this fall under the public or products liability clause? The answer, ultimately here, it didn't matter. At first instance, the judge had applied the public liability section of the policy. HDI argued on appeal that the product liability clause applied. This clause was almost identical, with the main difference being that it applied where there was a liability arising out of or in connection with any product. The appeal court accepted that there was some force in the argument that the product liability clause applied because the wording was widely drafted, but in reality, it made no difference. The problem arose because of the negligent installation. The second question, did cover extend to the removal of the cavity wall insulation? Yes, it did. The question here was really not whether Heatwave was liable to the claimant for the removal of the cavity wall insulation, but whether HDI should pay. The policy would only respond if the liability was one arising out of damage occurring during the currency of the policy. HDI argued there was no causal link between the liability and the damage, but the court disagreed. Interestingly, it was suggested that the installation of the cavity wall insulation itself constituted the damage. The third question, did all of the loss fall to HDI? As you would expect, HDI argued that the refurbishment costs related to damage arising outside of the policy period. However, this argument was also rejected. The court found that significant damage had occurred during the policy period, and even though the full extent was not apparent at the outset, the costs of repairing the initial damage caused during the period of cover were not increased by the damage occurring thereafter. So the appeal was dismissed. Overall, not a good outcome for insurers, and I would reiterate the need to review policy wording regularly and consider the scope of each section of the policy carefully. My second case, McLean and Thornhill, takes a slightly different note and considers the extent of the duty of care owed by professionals. Now, as we all know, a lawyer owes a duty of care to the client for whom he or she is acting, but generally not to other parties. Of course, there are exceptions, often depending on whether there is an assumption of responsibility. In this case, the question was whether a leading tax silk appointed to advise the promoter of 3 tax avoidance schemes owed a duty of care to investors. Again, the facts in this case are quite simple. The claimants invested in tax avoidance schemes. Before the investments were made, the promoters had obtained advice from Andrew Thornhill Casey, a leading specialist in tax. He considered the paperwork and gave positive advice on the prospects of the tax benefits being achieved. He consented to his advice being shared with potential investors. The scheme was marketed through the issue of an information memorandum which invited applicants to invest and included various warnings about the risks, including that they should consult their tax advisors. The invitation went further still, requiring a warranty from investors that they had done so. Some 10 years later, the schemes unravelled and the investors brought claims against Mr. Thornhill on the basis that he had assumed a duty of care to them, which he had then breached. The investors' claims were dismissed on the basis that there was no duty of care. The investors appealed, but their appeal was also dismissed. The Courts of Appeal considered the issue of whether Mr. Thornhill owed a duty of care to the investors. The Court acknowledged factors that pointed towards a duty of care being owed, including the fact that Mr. Thornhill was a person with special skill who gave his advice, knowing it would be made available to potential investors who were likely to take comfort from it, being positive advice from leading KC in the field of tax. The investors argued that a duty should be imposed by analogy with statutory liability for prospectuses on the basis that he was providing unusual services in a marketing type function rather than as simply a barrister. This was rejected by the court. Applying the assumption of responsibility test in NRAM and Steele, which can be seen on the slide, the Court of Appeal held that there was no duty. Here, the investors were high net worth individuals and largely sophisticated investors. They could only invest in the schemes through authorised professionals, and they could not subscribe without warranting that they had sought advice. Therefore, the appellants could not reasonably rely on Mr. Thornhill's advice without making their own independent inquiry, and Mr. Thornhill could not reasonably have foreseen that they would do so. The appeal court found that the judge was correct to find no duty of care arose. The decision will no doubt be welcomed by professional advisors, but also serves as a reminder that a cautious approach should be taken when providing or sharing advice. When considering whether a duty of care arises, the court's analysis will be fact sensitive, and there will be detailed consideration of the relationship between the parties, the advice given, and the circumstances, as well as whether it was reasonable for the third party to rely on the advice without independent inquiry. I'll now pass over to Andrew Tobin to discuss one final case.
Thank you, Andrea. Yeah, just one more case to go. One of my special interests has always been policy coverage issues regarding war, terrorism, and political violence. So I wanted to mention last year's decision in the case of the University of Exeter and Allianz, which was a very striking one. It's also a good example of a case in which applying the law might result in a different outcome to what one's gut feeling may guide you to. The facts were that in 2021, a £1,000 German bomb was found on the University of Exeter's campus, which could only be disposed of by a controlled detonation. It was duly detonated by the army, causing damage to university property. The university claimed under its property policy, which covered loss, destruction and damage. Now, nearly all standard property policies in the UK contain a war risk exclusion, and Allianz invoked just such an exclusion on the basis that the damage to the university property was, quote, occasioned by war, end quote, in the language of the exclusion, namely the Second World War. The university argued that the dropping of the bomb, the university argued that the dropping of the bomb 80 years earlier was not the cause of the damage, or even a proximate cause of the damage. In their view, the proximate cause of loss in 2021 was not the dropping of the bomb, but the decision to detonate it, and therefore the war risk exclusion should not apply. At first instance, the judge found that the bomb itself, and therefore the war, was the proximate cause of loss, and the exclusion therefore applied, and that the passage of 80 years made no difference to that. The judge relied on well-established cases that held that the real or effective cause of a loss is not necessarily the last event in time, but involves the application of common sense to identify the real or effective cause, and that reasonable human interference in the chain of events should usually not be considered to be a new cause in itself, a point which was recently remade by the Supreme Court in the COVID business interruption decision. Therefore, if one ignored the act of detonation, the only other candidate cause of loss was the dropping of the bomb 80 years earlier during the war. And so that was necessarily the proximate cause of the loss, and therefore the exclusion applied. Now, the judge went on to find that even if he was wrong about that, then the dropping of the bomb was at least a proximate cause of loss, and that it's a well-established rule that where there are two or more roughly proximate causes of loss, and one is excluded and the other one is covered, then the exclusion prevails. That rule comes from the case of Wayne, Tank and Employers from 1974. So if the dropping of the bomb itself during the war and its detonation in 2000 and 2021 were both proximate causes, then applying the rule in Wayne Tank means that the loss is excluded. I would just add in passing that the court refused to apply the contra proferentum rule that the university said should apply in order to resolve ambiguity in favour of the university. It found that there was no obvious ambiguity in the clause itself, but simply a question of how to apply the clause to the facts. And English courts have become more and more reluctant to resort to the contra proferentum rule over the last 20 or 30 years, and this is just another example of that. Now, the university appealed to the Court of Appeal and lost. The Court of Appeal broadly agreed with the first instance judge, although it found it was sufficient for it to find in favour of Allianz based on the two concurrent causes argument, that the Wayne Tank point alone. In the Court of Appeal's view, it was correct to see the dropping of the bomb and its detonation as concurrent causes, in that neither event would have caused the loss themselves without the other. On that basis, and applying the rule in Wayne Tank, the loss was excluded. Now, the university tried to argue that the detonation was clearly the more potent cause of loss, especially given the passage of 80 years, but the Court of Appeal disagreed. The fact that an event was first in time did not, even 80 years ago, did not prevent it being the proximate cause of loss, and there was nothing in the detonation that broke the chain of causation. And there's a long list of cases that demonstrate that point. And so the Court of Appeal upheld the judgment in Allianz's favour. So I'll just make a few observations about the case. So although striking, the decision is striking, the decision is correct in my view. It results from well-settled legal principles, particularly the Wayne Tank rule, the Court of Appeal decided the case by applying the Wayne Tank rule by saying that there were two concurrent causes and that one of them was excluded. That's clearly right in my view. And I would also say that the trial judge was probably right in finding that the dropping of the bomb during the Second World War was in fact the proximate cause of this loss. The act of detonation was reasonable human intervention, which should be disregarded when considering causation, unless that act itself is so significant as to break the chain of causation. Now, the only other candidate cause of loss was the dropping of the bomb itself, so it must have been the proximate cause of loss. I mean, that said, one wonders if the result had been the same had the bomb been 200 or 300 years old. Presumably, yes. Now, most war risk exclusions are even wider than the one in this case because they're expressed to exclude losses directly or indirectly caused by the political violence peril, which tilts the balance even further in favour of insurers, allowing non-proximate causes to be brought into play to trigger the exclusion. So, if the clause in this case had excluded damage indirectly caused by war, then I doubt this issue would even have reached trial because the war was clearly at least an indirect case, an indirect cause. Finally, I would just add that it's often wrongly assumed by our insurer clients that courts and tribunals have some inherent reluctance to apply war risk exclusions. I would just say that's really not the case, and there are plenty of examples from the law reports going back well over 100 years. And this case is really just a good example of many of those well-established rules being applied. Now, similar rules and clauses are all being crawled over again in the context of the Russia-Ukraine war cases. So we'll have to wait and see if any of those decisions change the law. So that concludes our presentation for today. We'd really appreciate it if you could send us your feedback in the questionnaire that will be sent to you shortly. Do join us for our next cover talk, which will be on the 14th of March, where our Helena Solomou will be talking about the Third Party Rights Against Insurers Act. Thank you. Please do send us any questions or feedback in the follow-up, but thank you all for joining us. So it's a goodbye from me, Andrea, Bradley, and Claire. Thank you very much, everyone.